oh, hey, I saw these comments and thought I would jump in as an attorney to just give some legal education. As I say, I'm a lawyer, not your lawyer. This is for educational and informational purposes only. This is not legal advice. It's just I'm seeing the comments on the same videos you guys are seeing, and I thought, let me give you some background information about subpoenas and how these things work, because there's a lot of people saying that they're going to sue and they're going to go after and this, that, the other, and just let me give you some knowledge so you can put it all in perspective as you're watching these videos, right? Here we go. Getting another person's medical records is possible in limited circumstances. It does usually require a lawsuit to be filed and a judge's order, because health privacy data is really protected, right? These rules are super strict. Now, the normal process would be you file a lawsuit, you ask the court for permission to obtain narrowly tailored records that are directly relevant to your claims. So without a lawsuit, by the way, a lot of providers are going to say, hell no, we're not giving you this information. There are limited situations and certain states that allow pre-suit subpoenas or pre-action discovery. Judges will grant these rarely. You have to show a strong need and a time limit. But again, because these health providers, they want a judge's signature. They're not just going to hand over somebody's medical information just willy-nilly, right? Health departments, which is who a lot of people are going to go to or try to go to get this information, they're even harder to get. State laws often add strict protections for communicable diseases, contact tracing, and public health investigations. A lot of times health departments commonly provide only anonymous or aggregate data unless a court order is provided, and these public health agencies, they usually are supposed to prioritize disease control and confidentiality, and they often resist identifying individuals absent a clear court order, right? So judge's signature is what you're going to need. So to get a person's records, you usually have to demonstrate relevance, necessity, narrow scope, privacy protections, and alternative options are not enough. You're gonna have to be like, hey, these other things that you're gonna say I could do, that's not gonna get me what I need to prove my case, right? Here's what the steps would be that an attorney would probably do. Choose the forum and then define the target records, be very limited to what you need, tailored, not going overboard. Then you would need to get the subpoena or the court order, right? You have to provide HIPAA notice to the individual who you're seeking this information for, a qualified protective order to limit who can see the records. Maybe it's just like attorneys only and then they're destroyed at the end of the case. You have to be prepared that there will be objections, right? And again, confidentiality safeguards, attorney's eyes only, and secure storage, things like that. Just to be a realist, I feel like I'm Debbie Downer, but these are just the reality. Lawsuits are not cheap and they are not fast, right? So there will be a time constraint even to get these subpoenas. I'm trying to go fast. So it could be weeks to months because there's going to be pushback. There's going to be motions to quash. Again, the cost of litigation, attorney fees, filing fees, service, all this stuff. And there's a possibility of sanctions if you go overboard on these requests. So let me know if you have any questions, but I hope this helps. Not legal advice. This is just education.